Good afternoon, everyone. My name is Steve Schulwolf. I am the chair-elect of the Dispute Resolution Committee of ABA TIPS, and it's our pleasure to have part one of a two-part series that we're doing co-sponsoring with the EDR section of the larger ABA. So that's the Early Dispute Resolution Committee. And we're excited today to be talking about risk assessment. And I'm here in Austin, Texas. I'm a full-time neutral. I arbitrate and mediate. And so one of the things when I'm mediating, I always hear parties tell me that the other side isn't being reasonable. And one thing that I recognized in becoming a full-time neutral is I've grown to appreciate how much the skill of evaluating risks and calculating the value of a case is distinct from the legal skills necessary to make determinations about probability of success. And it's the lawyers who can do both who are highly successful both at trial and at mediation. So one of our goals here in this two-part series, starting with this risk assessment series, is to talk to some experts who have vast experience in complex cases about some tips for how they identify issues, how they calculate evaluations, and how they generally do risk assessments. So I'm going to introduce our first panelist, Deborah Greenspan. Debbie is a former chair of the Dispute Resolution Committee. She is a partner at the law firm of Blank Rome, and she has served as court-appointed neutral in very prominent cases. She was Ken Feinberg's deputy in the 9/11 Victims Compensation Fund cases, as well as serving as a court-appointed neutral in the Flint, Michigan water cases. So Debbie, welcome. I appreciate you being on this panel. And I guess the first question that I have for you is just taking a step back. How do you start the process to evaluate a case?
Okay, big question, Steve. We start at the beginning, right? So thank you, first of all. Thanks for leading us on this panel today. So of course, every case is a little bit different. And I think one of the things we wanted to do today was talk a little bit about complex cases that involve multiple parties, because they kind of teach you a lot of lessons about how to approach cases and how to approach the risk analysis. So if you're going to start looking at, you've been sued, let's say you're a company who's been sued and you are now taking a look at what are you facing, and you've got your team there to help you assess what your, and we're going to use the word risk, what your risk is in this litigation. So multiples of, there's a number of factors to take a look at, of course. So starting, I think initially with what is your potential exposure? Can you define that? Can you, if you understand what the case is about, what the claim is there just one person who has this claim? Are there 100,000 people who might have that claim? What is your ultimate exposure here? Can you begin to start to understand what you might be facing? You might have been sued in a single individual case. You might have a class action. You might have maybe a group of cases that have been brought. And one of the challenges you might face and need to consider when you're assessing risk is, where are these cases? Are they in federal court? Are they in state court? Are they in both? Are they in multiple jurisdictions? Are they in a single jurisdiction? All of those factors start to affect how you might analyze your situation. And I'm mentioning all of these things because these are just a part of the puzzle that you need to put together to start to understand how to proceed and how to approach the case. I'm going to mention, I think just starting out, I said, what do you actually have out there? This brings you to the question of what's your data? What information can you compile and understand about a case? So if you, I know we're going to talk about some case examples, but I'll mention one right now. I've worked for many years on some litigation involving implanted medical devices. And so there you might be looking at how many of these devices were sold, how many people might have these devices, what kind of information can you compile? Because if the litigation grows, when you start deciding how to assess your risk is going to involve understanding your ultimate exposure and how best to contain that exposure or to address it or to understand it and evaluate it. Steve, I don't want to go too far ahead with, our timeline here. So if you just tell me when we move on to our next topic. So I don't want to keep going without checking in with you first.
All right. Well, first of all, you're our superstar, so you're allowed to, talk on. But no, I appreciate that. And in fact, this gives me an opportunity to tell the audience we do have activated the Q&A button. So if at any time there's a question that folks have for any of the panelists, I will do my best as moderator to review the questions and answers that many of you have. But Deb, you talked about data, and you talked about knowing where a case is venued, who potentially is bringing a case. There's a lot of data involved. How do you go about feeling comfortable that you have enough data? And if you don't have enough data, what type of things do you do to improve your risk evaluation?
So there's going to be people who say you can never have enough data. So that may be one of the statements, but you have to start, just like with anything at the beginning, how, you got to know something about the size of the population that might be affected by this, by whatever the issue is. And then what are their characteristics? Can you learn something about this population that might affect how you would approach the case? Are there particular facts that you want to gather about individuals? So for example, you will frequently see, if you have a multi-district litigation or some sort of consolidation, one of the early things that you would want to do is gather information about the plaintiffs who have brought suit. They're called fact sheets, or there's other kinds of compilations of information so that you can get your arms around the scope of the litigation. But that's not all, because not everybody is actually in the litigation. So you also need to understand the outside exposure here if you're facing litigation. So of that kind of complex type. There are many different ways to gather data. And maybe Tim Raab might maybe speak about that, but I think it's a threshold issue. The more you can get, the better off you are, I think, is the way I would describe it.
Okay. Well, I am gonna get we have two Tims on the panel here. I'm gonna first go to Tim Raab. Tim, I'm gonna allow you to introduce yourself. You have a background, an extensive background dealing with complex cases, but I'm going to throw the first question to you based on what we heard Deborah say a little bit. And, one default, I think lawyers are always control freaks. They want to have as much data as possible. And I think there's a fine line between the cost benefit of acquiring data and what makes sense in any particular case. And so I was wondering if you have any thoughts about the best way to efficiently deal with data, because like I said, this is a series that's sponsored in part by the early mediation, early dispute resolution. And sometimes early dispute resolution involves all sides acknowledging that maybe they don't have perfect information. So, is there a difference between perfect information and enough information, and how, any tips that you have on that? But first, introduce yourself as well.
Yeah, thank you. Thank you, Steve, and thanks for having me on this panel. I'm a managing director with Alvarez and Marsal, and I lead our mass torts and complex litigation practice here. My experience goes back to some of the early cases in the early 2000s with asbestos being a major focus of ours years ago, and kind of really where some of our methods that we're using today to do these kinds of things were born, essentially. So I think when Debbie said, there are people that say there's not enough, you always want more data, that's us. That's the kind of business that we're in. But we've been, given how long we've been doing this, not just with asbestos, but the landscape has changed significantly today from just the number and variety of cases. One of the things that we look at when we'll call it data availability is how mature or immature the issue is. Okay, so when you're looking at asbestos that's been around a long time, you have a lot of studies, you have a lot of actual estimate methodologies that exist, some methodologies that are accepted by the courts that have been used, you can point to. You actually have studies done for incidents of disease that underlie your estimates for forecasting liability. In those circumstances, I would say in that, for those kinds of issues, you have enough data. Okay, so I would say that the data exists and you're able, from our perspective, to provide an estimate that likely is defensible and that probably won't necessarily be too hotly contested outside of just assumptions that you have to make. So the first thing we look at as a fork in the road is how mature is the tort? How much is out there? And then you get into the areas where, and more of this is the case today, because there are many new issues, emerging issues. Again, I'm speaking in the context of aggregate litigation, mass claims, that require, I would call it, some creativity in data, right? So you want, I'll call it primary data, where you're looking at actual company information, and then we supplement that with publicly available information. There's a lot of information for sale that essentially you use, we'll call it tertiary information, that we bring into our models to help inform us of whatever the circumstance is for the estimation. So, when it comes to the amount, how data gets extracted, obviously digital information is way more available today than it used to be, especially with classes dating back or injured groups that date years back in the past, even if they're now 10 to 15 years, if the issue maybe dates that far back, data is in a better form than it was, say, 10 or 15 years ago. So I would say generally you can get more data than you used to be able to get. But I will also say that I'm never going to say too much data, but the challenge becomes which data is the most important, or especially when you're looking for data outside of the case itself to use to support an issue. You have a lot of it. There's a lot you can use. And I think that's where it becomes a bit more difficult, because there is kind of an overload of information today with how you go about selecting data for the purposes of using it and estimating liability. Okay.
And we'll come back to some of the more detailed aspects of that, but I want to get our other Tim McSwain involved. And Tim, we've heard a lot about data and estimates, and I know you wanted to talk about, how we get parties vested in understanding risk so that they're open to an early resolution, or they're open to potentially settling a case. Go ahead, introduce. I know you've got a great background in complex aviation matters, and please introduce yourself and then talk a little bit about what you do to get people vested in the process.
Thank you, Steve. I began the practice of law on my own. I was one of those guys who decided he could do it better than I could do it anywhere else. And plus I was, of course, in the half of my class that supported the upper half of my class. So I was not going to get any offers from white shoe firms. So I just hung out a shingle and immediately started malpracticing. But I sure learned a lot. I worked for a while as a public defender. I've taught college and law school classes from time to time. I did a couple of real estate deals. I did one domestic relations case and decided that was all I needed to do of that. And the rest of it, I did that for about 10 years. And then I was invited to join the ranks of United States aviation underwriters in New York. I was recruited to come and help with their claims group, which I did for 21 years there. I was then recruited by Allianz of Germany to help stand up their aviation practice in North and South America. I did that for 8 years, and then I retired, and I was retired for about 3 weeks. And then the phone started to ring with people I knew calling and wanting to know if I could help them with this or that case that they had going on. And that's gone on for 10 years now. I never expected it to last this long, but at any rate, I've been doing that. And in the course of that 10 years, I've had an even broader exposure to the business and the practice of law than I had beforehand, because I've functioned in numerous capacities in that 10 years. And it's been a lot of fun, actually. I've enjoyed it immensely, and I don't plan to quit anytime soon. And that's enough of that. How do you get parties to be open to settling a case? Rule 1, you have to get them either to not hate each other or convince them that they do not need to hate because it's contrary to their client's benefit, which often interferes with settling a case. My exposure to mass tort litigation is limited, although the Tucson water pollution cases stands as kind of the high water mark. I ended up handling pollution cases from about 1989 on. I missed a meeting, and then the first of the pollution claims that came in were assigned to me because I wasn't there to defend myself. The good news is it got me introduced to a world that was much different than the one-on-one or two-on-one or one-on-three, whatever litigation that I'd been accustomed to. That said, when I say getting the parties not to hate each other, there's 2 components to that. In the first place, unfortunately, some members of the bar can't help themselves. They're organically wired to hate anybody on the other side of the case, at least for the purpose of that case. Getting past that sometimes is the most difficult part of getting people to be open to agreeing, because there's a whole lot of showmanship that goes on depending on who's present when the matter is discussed. Someone may be grandstanding for the sake of their client, and that gets in the way. And it's usually a little pep talk that I would try to give to people if I was involved in trying to resolve the cases, which I virtually always was. The first thing you have to do is convince them that they should not approach this as enemies. Sometimes that hostility will come from their clients. There are certain clients, particularly in the aviation business, who have a great deal of pride in their product and don't wish to concede anything. One of the things that would strike terror into a mediator's heart, I would think, is when somebody says, we're going to teach those other guys a lesson. Because now you've got this thing out there. Somebody's looking to be an instructor instead of an advocate, and to warn other people away from making similar claims. In my experience, that almost never works, and it certainly isn't conducive to settling the matter that's before you at the time. So that's step 1, in my view, about trying to get people to be open to settling a case.
All right. And I think that's a great lesson, that we can talk about numbers, we can talk about data and analysis, but if we don't have people who have open minds, and they're running on emotions, they're unlikely to be open to actually fully considering those risks. We've got so many experiences here in this panel. I think it makes sense to ask you all to share a little bit of from some specific cases. Tim, you were talking about you started doing environmental cases. I actually have an example of what, in my opinion, what I said up front was about how attorneys can both analyze cases and effectively represent their client. This was before OCR and dinosaurs roamed the earth, and when you did document productions, you couldn't search to make sure you weren't necessarily producing privileged information. Now, I was in a case, prominent firm, prominent attorney. They produced a 20-page memo that basically said that they thought they only had a 5% chance of winning the case. It was a $100 million case, so 5% of $100 million, it was at least worth a shot. We returned it. You can't untie that knot, and jokingly, it wound up being something that turned out for the best for that attorney, because ultimately, when the trial judge started issuing rulings that made it fairly obvious that the court was going to help out and maybe make that 5% a little bit higher, other folks still didn't settle when they gave them the opportunity to do so. And we did. And when I wound up years later having a beer with that attorney, I said that inadvertent production, wound up, costing a lot of other people. But what was interesting to me was during that litigation, this attorney would get up and tell the judge, it was sanctionable to even think that their argument wasn't meritorious, even though we all knew that they were able to, behind the curtain, assess the case at a much different valuation than what they were in litigation. So that's my rambling war story. Deb, you've got much more I guess prominent experience in some cases. As I said, you've been involved in the 9/11 Victims Compensation Fund and some other prominent cases. So why don't you give us an example of some cases that you were dealing in terms of where valuations had to be made, and use your experience to illustrate that. Well, you're on mute, Deb.
Sorry, I had put myself on mute before, but so I want to start out a little bit with on the theme that you just raised, because one of the beneficial factors of really compiling data and analyzing it, and particularly if you can use even a neutral to help do that with parties in a mass case, is that you create a sort of a framework for everyone to discuss something. So in other words, if everybody agrees that there's 100,000 of these products out there, at least you have that in agreement, and you can start chipping away at it because you have some sort of framework in which to work. So I'm going to give you a couple of examples of just sort of what we were talking about before, which is evaluating what you've got in a population in sort of a very concrete way, and then maybe a slightly different way. I'm going to use one example, and actually this is the Flint case example, that in the course of discussing resolution of that case, one of the issues is, what is the population and who are they, and what claims do they really have? And you can get some of that from cases that have been filed, but when you're talking about something that expands beyond, is bigger than the cases that have actually been filed, then the question is, well, what else is out there? Because if you want to resolve something, usually there's at least a desire to make sure that you're to try to resolve everything and not just a piece of it. So at least if you understand what's there, you can consider that. So in that case, I took on that role of trying to figure out what actually was what we were facing, and I was a neutral, so I wasn't doing it for one side or another, but trying to understand the population. And that wasn't, basically there are a lot of sources, as Tim mentioned. We had census data, we had a lot of health data that had been reported about a particular population. We had economic data, we had, financial, that partly comes from the census and other sources. We had information about the ages of the population in general. We tracked birth rates every year for the period of time that we were talking about here that was affected by this litigation. So we knew how many new children were born each year. And the reason I mention that is because this is a litigation that is in the damage claims are in large part focused on the very youngest children. So it was important to understand the scope of that population. We had information from water testing that, was available to understand what kinds of contaminants were in the water or what had been tested for. We had really a lot of information that was publicly available or that you could get by requesting it so that you could put together an entire analysis. And then you can share that with the parties and you can say, okay, here's what we have out there. Here's how many cases have been filed. Here's what their characteristics are. And then you have at least something that's in common to work with and to talk about. That's just one concept and one approach. And I think because you mentioned valuation, I will move to a different case, or to a different situation, which is the 9/11 fund, because in that particular case, there was a question about how to value claims. And these are claims of people who were either killed or injured in the 9/11 attack. There's, in the initial fund, and then there was a second phase that involved people who were living in the area or cleaning up in the area. So they're kind of different sorts of claims. But in the first phase, one of the tasks that was that the statute, the compensation program statute provided was to determine economic loss and non-economic loss. Now, there's ways to determine economic loss. We all know about some of those mechanisms. They're pretty standard. There may be some different assumptions you apply, different pieces of data, but it's basically the same kind of framework. So you have to start with the initial data about earnings and age and all of that, but that's not mysterious, really. It's pretty standard and straightforward. The issue was non-economic damages, which is the pain and suffering and the consequences of the injuries, both to family members and victims. And so that part of the process involved really getting a kind of an overview of the types of situations that we were facing in the population. So you may be thinking, in the initial 9/11, people got killed and that's what you understand, but there were thousands of people who had injuries, and they had a wide variety of injuries ranging from smoke inhalation or some sort of dust inhalation to burn victims with, very serious burns, crushed victims. I mean, there were all kinds of different sorts of injuries. And the issue is, how do you put some sort of value on that? And that process involved looking at verdict values, compiling settlement values from data sources that are sort of out there that you can get a hold of, interviewing people, meeting with people, understanding their, getting testimony from them really about their situation, understanding the medical consequences that some people face, it's a permanent disability, or it's something that they'll recover from. And so all of that went into creating a scale of values in that particular situation. So it's, but there's sources, you don't have, in I guess the asbestos cases that Tim was mentioning, you have historical settlement and litigation values for years that you can apply when you're trying to assess a resolution process in the context of those cases. But in this situation, we didn't have any history. We didn't have verdict values. We didn't have cases that had been litigated. But there are other outside sources that can help you value the nature of the injury. This is putting aside causation and liability, because in that case, that wasn't an issue. So it makes the job a lot easier. But just to even put a value on the injury, there are data sources out there. And there is a way to actually do that and to make those values consistent and to make them relatively sensible and reasonable.
All right. Well, thank you. Thank you. I'm going to move this over to Tim now. Tim Raab, and I know you have extensive experience in some of the NFL concussion cases. And then when we talked about this, you might have some experiences, but I am going to weave in a question that we have from the audience on that. We have a two-part question. I'm going to direct the first part to you, Tim Raab. The second to you, Mr. McSwain. But Mr. Crumpton says, rather than quantity of data, how do you design and achieve the most objectively reliable data in a system that fosters adversarial, partisan investigation, and expert evaluation processes that create divergent evaluations and positions? So in other words, our system, each side is going to come up with its own evaluation. And I think you and I talked a little bit about maybe early communication, but what are some thoughts you have in response to that?
So that's a fantastic question. It actually works very well with the cadence of what we're doing here. So it's a great question. And I actually can give an example of it with a case that I was on recently, working essentially as an expert, within the context of a sexual abuse case for a diocese, okay, or series of cases or many cases. And I think my background in mass tort aggregate litigation is a lot less like a battle of the experts and a lot more about trying to solve a problem. Okay. So it's not always the case that it's that way, but oftentimes, especially for disaster cases that happen immediately, you want to gain some ground with the other expert, especially if the parties are willing to start, agreeing on things, because the way you will approach, I'll say it this way to answer part of the question, even in the cases like a sexual abuse case where there isn't a lot of data necessarily available, you basically have descriptions of what people experienced, and that's limited based on agreements to how much information can be shared. So the diocese doesn't want to share certain information they have. The plaintiffs don't want to make it burdensome for their clients to file, voluminous information. So essentially what you've got is descriptions and detail, or as much detail as you can get. So the process by which you evaluate the liability isn't going to be very different. There's a lot of similarities between one side's expert and the other. And if you can immediately and quickly begin to kind of check through those, and that requires communication early. And we did that on a recent case where, as early as the investigative data collection phase, well before an expert report, we may not even have to get to expert reports. Okay, we may not have to get that far because we have agreement on things like how many claims there are and what the quality of those claims are, right? So we take a shot at saying why we think they have, they have a certain level of quality, meaning they're good claims. I'm not saying the level of the claims, but how good they are, or if they lack information, and we come to agreement on that. We actually then come to agreement on the level of severity of those claims. So instead of simply working independently, at least in that example, we didn't. We worked kind of together. We did have some discrepancies, obviously, but they were resolved with a request, in some cases, a request for more information. And we got to a point where we were working in the same, as Deb said this, in the framework is what is important. And the reality is kind of what I said before, there isn't an enormous amount of difference, if not at all, between an approach from an expert side. Now, what's going to differ are assumptions, and then you get into values and how you select verdicts and settlements, especially if you don't have a scientific basis to come up with some underlying estimate of value outside of economic loss. If you're looking at comparables, I'll call them. Now you're getting into assumptions you're making about what the relevant comparables are, and those decisions can yield different results. Those are assumptions one may differ on, but 80%, 70 to 80% of the process on each side by each expert is generally the same. And if you can get to that point where you come to that agreement early, it makes it a lot easier, and you could potentially avoid a lot of the unnecessary, in my reports here, there's another report, way out in a totally different range than my report. And essentially what happens there is a judge or mediator has to, do their best to say, how am I supposed to, which one is right? So then they have to split it down the middle, and I'm not sure what that necessarily achieves either. So, you avoid some of that fighting, if you will, with early communication between kind of the approach and framework of the experts.
Excellent. Well, and like I said, Mr. Crumpton's question, it was a two-part, and I think I might lose my job as moderator because he very much knew how to point you in the right direction. So, Mr. McSwain, the second part of this question was, secondly, how do you move the needle from litigators' adversarial, partisan stances and strategies to more collaborative, objectively fair, mutually beneficial options to explore? I know you hit they can't hate each other if they're going to be able to, cooperate. What are some other tips that you have to avoid it being partisan warfare?
A lot of that depends on the experience of the counsel who are involved, because I don't know that you will ever get lawyers to truly abandon the advocacy role. They will always want to be on the side of their client. That's pretty reliable. And to ask them just to be reasonable is probably, it's difficult to get anybody to really buy into that. You have to have something that they can use to make themselves feel like they're being reasonable or realistic. And the best way to do that is with information, data that you've accumulated. I don't want to make any specific details, so I'll use a generic example. You have an airline accident with 300 fatalities. So you've got 300 claims you're going to be dealing with. There might be 200 different lawyers representing those 300 claimants. And what will happen as the case develops is you will be able to get a grid of where the settlements are going. And to the extent that you can do so without violating any confidentiality agreements, you can help make counsel aware of that. And it's kind of interesting because there has always been a debate in such cases. Who gets the best deal? The first to settle or the last to settle? And you'll have people who will come into the mediation with a preconceived notion about the truth of that statement. And if you can find out what their view is of that, it'll help as a mediator to try to get them to see the benefit of their position or acquaint them with the downfalls of that position. And it's as Tim said a moment ago, it's all about the assumptions that you have to make. When you do have two experts, particularly economists, and I love economic expert witnesses, because you can have two people with identical credentials, identical experience, everything, it seems to be the same, methodology looks the same, and they come out with numbers that are an order of magnitude different. And that has led me over the years to sort of conclude that best you can do is talk to the advocate with the very high valuation and ask them candidly to appreciate the possibilities that the case might come in at the low valuation, and vice versa. And it is a challenge sometimes to get people to do that, but it's all a question of trying to give a notion of reality. And I did have one case where I had the opportunity to utilize the result from a focus group to talk with the lawyer who had a really unrealistic valuation of the case. And he scoffed at the jury verdict research. And I recognize that people has its advocates and its scoffers. I'm somewhere in the middle. And I said, well, that's fine, Mr. X, but what if it's right? What are you going to tell your client? Because you already have an offer that's better than what the focus group came out with. What are you going to tell your client, especially when she finds out that you had an offer that was better than the end result? I think the case will go on, but it will have a different defendant at that point, perhaps. So I think you can sometimes use that kind of a tool, if you have it available to you, to get some sense of reality into the parties.
All right. We've got another question that I think dovetails nicely. I'm just going to throw this out here. It's along the lines of tools. To what extent do you use risk assessment software, particularly decision tree software? So that might be a Deb or a Tim Robb question.
Can I just piggyback on one of the things that was just talked about here?
Oh,
Before
sure.
getting into that question. So I've been involved in many cases as settlement counsel, and one of the ways that you have differences in the way you approach it, if it's a mediation, for example, is separating out the litigators from the people who are charged with the obligation to see if they can reach a settlement. And you have a different job at that point. You are representing your client, but you are representing them because they've told you they want to come up with a settlement in the case. And they deliberately keep you separated from the litigation itself. So I've been in that role, and it is a different kind of dynamic that you end up with. So it's just a thought. And I also, in terms of the experts, when I hire an expert, I usually do my own analysis before. I mean, I know where I think it's going to come out because we have done so much of this, you understand it. And so then when the expert has their initial report, you can then dive into it and really kind of poke at the different kind of assumptions that are made. But that's true of if you have 2 or 3, opposing experts, you just have to understand what it is, what has been done, because you can pull them apart. And you can then, as you're a mediator, you can explain why you think assumption A, are you really sure about that assumption? Because there are other ways of approaching it, and they may not, and they may be just as valid. And I think if you're able to do that, if you have enough of an understanding of the case or the methodologies, that can be helpful in that process. And then just to get to your other question, Steve, I've never used software, but I do a decision tree. Like you start here, if you go here, this can happen. If you go there, this can happen. And it's sort of like a whole map of the case when you're doing a risk analysis of where it can go, what can happen, different decisions that you make, different approaches that you take. And then it's like a living document that you change as things happen. So I think it's essentially the same. I just haven't used software to do it. So.
Yeah, we don't use risk-based. I'm not aware of a risk-based software program that we use, but our main go-to, we use SQL, SAS, and Python, and all of those we build models, probabilistic models, kind of exactly what Debbie just described. So you're building models within those environments, and that's what we're using. We're looking at regression analysis frequently. That's typically used regularly in this space. But I wouldn't say there's a specific software outside of the ones I mentioned, which are database and analytics software that we use to do these models, to build these kinds of models.
Okay, and there was a follow-up question so decision tree, basically what's the likelihood of one issue being decided in a particular way, and then you can go down the different branches. If you win that issue, then that might mean a different issue is, needs to be estimated. So we have a question here of a basic idea, some insight about how you come up with the particular percentages. So if the first, shoot in a decision tree is, are we going to win summary judgment? And you've got 70% yes, 30% no. What are the factors that you all employ to, in thinking about, the likelihood of success and the percentages inputted into decision trees?
It sounds like a swag calculation to me. I don't know of any way really to estimate the likelihood of success of any particular motion or any particular litigation overall. I will say this. I had a case some years ago. It was tried in Connecticut, and the jury verdict came in at multiples of what we expected. I mean, it was hugely different. So they have a process in Connecticut by which, if you want to go to the appellate court, or if you want to appeal the case, you have to go to a pre-appeal mediation sort of deal. So we had a meeting about this. What does this mean? And I was assured that what it meant was the judge, who was a retired judge, said, well, don't worry about it, because the trial judge is going to remit that verdict. guaranteed. All right. So we went back to the principals and said, all right, we're going to take this, but we're going to make some post-trial motions and have the quantum, at least, remitted to a more reasonable level. We were assured that that was what was going to happen. So now you know the end of that part of the story. It didn't happen.
Yeah.
So then the next step was we were going to go to the Supreme Court of Connecticut. And I don't remember if they call it the Superior Court or Supreme Court or what, but so we were going to go there. And again, I consulted with someone who was reported to me to be the best appellate lawyer in the state. So talked with that individual, and he assured me that the Supreme Court would not even hear the case. They would send it back for the trial court to remit it or something else. Fine. Guess what didn't happen?
Yeah.
They took the case. At that point, the same lawyer told me, don't worry about it. The Supreme Court is going to reverse and remand. And I said, well, look, I'm a 3 strikes kind of guy. You've got 2 strikes on you right now. I am not throwing you the fastball for the 3rd strike because I'm afraid the other guy's going to hit it out of the park. So I was able, in that case, it was a matter of persuading the client to settle the case, which they did. But that's why I don't have a whole lot of faith in people who want to give me probabilities of winning. You always have a chance of winning. You always have a chance of losing. And I know clients always hate lawyers who say it's 50-50. Well, okay, but that's the reality of the world we live in. I don't think it's not very often you can call your shots. I do know of a couple of cases where lawyers did do that, dozens of them, I'm sure, but the ability to call your case really takes a lot of experience and no small amount of luck, in my opinion.
I really look at this very differently than that. I don't really try to say, we're going to win summary judgment, we're going to lose summary judgment or something. I think when you're looking particularly at complex cases, one of the things to look at is what are all the things that we're going to have to go through? How long is it going to take us to get to a summary judgment motion? Is that going to be a 3-year discovery process before we get there? And that's just one piece of it. And start to look at the whole picture. Where is it actually going to go, and what are the options for where it can go? If you have particularly difficult scientific issues, these cases can go on for a very long time before you would get any sort of definitive ruling on something. And so I think you're not just saying, okay, if we win summary judgment, we're done, and that's what we should put all of our eggs in that basket or something. You obviously have to consider all the different alternatives, but you also need to look at the whole, what are you really doing here? How much are you going to be paying in defense costs or, litigation costs, or how much are you going to be incurring in expert fees and all of that? And is it going to be 10 years before you get anything? If you don't have a dispositive motion that really ends the litigation, which is not always the case, it's not that common, then what are you looking at? And that's part of your equation, part of your process of considering how do you get to resolution? Because at the end of the day, that's what everyone wants to get to. They want to win, but they want it to be resolved. So I think there's other factors to look at than specific, like dispositive issues. I mean, every time it seems like I meet with people a lot where they're waiting for the Daubert motions to be decided because they think it'll decide the case one way or the other. Sometimes, occasionally it does, but it often doesn't. And you often end up, then you've got to face the 10,000 cases that you've got in front of you anyway.
Yeah,
So-
we try to stay away from the probability analysis with the legal issues from where we sit. So when we estimate and, when we work for special masters or lawyers, we're showing you the economic impact, I'll call it that, which is devoid of whether you're devoid of the legal issues. So we're estimating what the impact will be, period. And that really shouldn't be any different, regardless of which side you're on. We've already talked about assumptions, but essentially we're not, and we have, but we don't often get involved in assisting the lawyers with some type of analysis on past judgments this judge has made, this jurisdiction, how favorable is it for this or that, and assigning probabilities related to that. That generally lawyers kind of lead that effort, at least in our experience, and will help with some other research if need be. But we separate that when we look at, we're more focused on the economic impact of the issue, if that makes sense.
There's full hour sessions devoted to, as a society, we seem to have shifted a little bit since COVID and attitudes of, jury pools. And so I've seen many presentations with trial attorneys who have said, look, my playbook 5 years ago is different than my playbook today. How do you track, in terms of on the economic side, what's considered a blip in the radar and what's a trend, in order to feel more comfortable with some of the assumptions that you use?
Good question. What I'm wondering in respect of a number of these issues that have been raised, I think we're looking at a seismic change in the practice with the increasing sophistication of artificial intelligence. I think you're going to find that it has multiple uses in doing the kinds of research you're talking about, with the caveat, of course, that the interweb is full of nonsense. But there's going to be a difference here, because when I started practicing law, we still did shepherdizing in great big books located in the law library. And how many years has it been since you even heard anybody use the term shepherdizing? So it is just, I think we're on the verge of a real change in the way that we do things, because I think AI is going to draw a lot of the air out of the room with the research that we're talking about, because people are going to be able to do vast amounts of research very quickly. And then your task will be to sort out the wheat from the chaff. And that may be as big a task as doing the shepherdizing in those big old dusty books too, but you'll sneeze a lot less.
Yeah, I remember learning how to shepherdize, but please do not ask me. I remember cross-referencing and going back from one book to the other, but that's about all I remember. Speaking about memory, I do want to remind folks that part 2 of this series is on June 4th. It's Mastering Early Mediation Strategies for Success. We have an upgrade in moderators, as Felicia Harris and Ellie Villander are moderating. We have 2 judges, one from California and one from Texas, Judge Edison and Danindra, and also a mediator will be helping that discussion. So I wanted to remind people that's June 4th at the same time as this one, and we hope to see you there. I do have one last question, I think, from the audience. It happens to be from Rick, Deb. So we have our current chair, Rick Alamonte, asking any tips on handling divisive insurance structures. Example, when an insured has a high SIR near the settlement value, but gets a free ride on fees. So, I guess to me, he's got a general and a specific question, one particular insurance structure. But I think the general question is, how, a lot of these cases, these complex cases, you're dealing with parties and you're also dealing with insurers. How does that impact the dynamic of case evaluation? Any ideas on that?
Well, yeah, it doesn't help a lot, because it just puts a third dimension into the problem. The conflicts between insurers are just always amaze me, because at least in the aviation and marine world, the chances are excellent that the companies are suing themselves. They end up having multiple interests in multiple levels of the insurance structure that's involved. And they may be involved on the first level and the third level, not in the second level. And that gets very complicated. I would suggest to all who have interest in such a subject, check your malpractice coverage carefully.
Deb, your screen popped up for me.
It's very complicated, and you end up, especially if you're in one of these big mass claim situations, you may have parallel litigation going on. You have the underlying litigation and you have the coverage litigation going on at the same time. And, you know, and it creates which goes first kind of question. You know, if you're, so it can be very complex, but also the very beginning, the topic of this whole webinar is litigation risk. And so that is something that's pertinent to the insurance carriers as well, because if it's going to touch, if you show an analysis that's going to hit their layer, you know, and there's a, you know, it's a reasonable analysis, that has some bearing. It can have some bearing on the whole discussion and the whole set of negotiations. But you kind of have all these different negotiations going at the same time with different layers of insurance with different you know, different interests, and then their reinsurance issues. So, but I think if you are able to analyze what you've really got, what the cases really are about, what can happen out there, it can help get people, as we started out by saying, at least you have a framework to talk in, so that you have some sort of common ground, basic facts to start having your discussions. But it gets very complicated.
Yeah, interestingly enough, I think the insurance element of the case I mentioned earlier, the sexual abuse case, was part of the reason that defense and plaintiff experts came together early, because we knew we'd have to deal with the insurance company at the end. So I think that was, for us, it actually created a you know, a mutual understanding, because insurance was such a big part of that kind of a case. When it becomes that big of an issue, when it's the lead, you know, funding mechanism for a lot of these, I think that at least that was the dynamic that we saw.
Well, that's interesting, because I know you had mentioned, Tim, you know, the importance and the benefit of trying to come up with upfront agreements. So, you know, have you seen a trend, whether that's more or less difficult if insurance is involved, or each case is always its own different dynamic?
I mean, the insurance element always adds a layer of like this, what I just mentioned. So you kind of take it in stages, but outside the insurance area, you know, there's examples of certain cases where the parties have their heels dug in, and I don't know how you're going to fix that. It's just not going to, no matter what we do, it's just not, you know, going to happen. But I do think from a statistical standpoint, just from a maybe a macro understanding of how many cases are out there now, how many different kinds of cases there are, the size of them, the complexity of them, it seems that settlement needs to be a bit more, it is a better option in a lot of cases. And there's a lot more settlement being done quietly, you know, maybe not the ones in the news that you're hearing about with the large MDLs, but we're seeing an uptick in both creative ways for companies to exit certain mass liability issues that maybe aren't bet the company size, but something smaller, and an interest in a bit more on the settlement route, which I think probably has to happen given the increase in volume and complexity.
One of the common sayings in the insurance industry, the insurance side of the house, is the only claim you're really sure about is the one that's in the closed file drawer. So insurance companies are, with a very few exceptions, rarely affected by emotion. Having no heart means you have no emotions, I guess. I don't know what that means, but it's in nobody's interest in an insurance company to have a case trailing along for 3 or 4 years. And as I have often counseled people, that claims, they're not wine, they're more like fish. They don't get better with age. So usually the insurance company will be a good avenue for settlement if you also have a plaintiff who has dug in their heels personally. But if there's insurance involved, that may make it easier for them to settle a case, even if there is a possibility they still have to pay something out of pocket because the claim exceeds a limit. So it's not a negative, but with very few exceptions, insurance companies don't get emotionally involved.
All right. Well, we're running up in time. Deb, I'll give you the last word if you want to wrap things up. Otherwise, I will.
I'm just gonna say it's to your benefit to do your homework. If you understand the case and you understand the other side's case as well, which is very helpful. And you can start to develop an understanding of where, forks in the road and where things go. If you're the mediator, you really do need to understand, I think, if you're in a complex situation like this, both sides, and then you need to be prepared, I think, to throw out some ideas about how you can develop a common framework in which to discuss the case by doing, your own analysis or getting the two experts together and finding out where their differences are, which are usually, as Tim said, very, they're not the majority of the analysis, they're the minority of the analysis. And then one last point, which is, I think we've all done this, one way that judges used to get us to settle is to trap us in the courthouse overnight, maybe for days on end, where, and order the insurers to be there and you can't leave. And that's sort of the old school, but it actually has happened. We've all experienced, I've been there, spent the night in some of these courthouses. It's lovely. And so, that is the old school method. I don't know if anyone wants to say.
There was a federal judge in Texas who was famous for saying something to the effect that it's hostages to justice.
Yeah. So we don't really want to do it that way, but it's out there.
Well, we appreciate everybody here. We don't consider you hostages. So on behalf of the EDR section of the ABA dispute resolution section, and on the dispute resolution committee of ABA tips, we thank both Tim's and Deborah for participating in the panel. Remember June 4th. For those of you who are interested in these type of issues, we have monthly meetings for the dispute resolution committee. We welcome input both for practicing mediators as well as folks who litigate and are constantly coming up with better ways to present their arguments at mediation. So thank you, Tim, and Deborah, and have a great afternoon, everyone.